As your case is getting closer to trial, the defense attorney calls your attorney up and makes a settlement offer. What happens if now, after learning about that settlement offer, you reject it? You want to know what happens? Come join me on this walk as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. There are a number of things that are going to happen after your attorney calls you to tell you about the settlement offer. If you turn around and say, look, I don't think that's an appropriate number, I'm not settling my case for that amount, fine. Now your attorney can go back to the defense lawyer and simply outright reject their offer. Counselor, this is not an appropriate offer. We have nothing further to add and there will be no counteroffer. That's one possibility. Another possibility is now, after you've discussed the settlement offer with your attorney and discussed the risks of not accepting the offer, now your attorney can go back and make a counter offer. Okay, counselor, your offer is totally unacceptable. However, we are willing to accept this particular number. And now he throws out the number. Now, the defense attorney will do one of two things. Either he will say, listen, I don't have authority for that amount. I have to go back and speak to my principals, speak to the people who are in charge of giving me the money, and then I can get back to you in a few days and let you know. Or he can now have a discussion, a negotiation with your attorney to then discuss the merits of whether or not your case merits this particular number that he's now thrown out. And based upon that, he might actually have authority to offer more money. In which case, if he does, your attorney will then reach back out to you and tell you, okay, I spoke to the defense attorney again. He has now increased their offer to this number. What do you have to say about that? Most people think that when the defense offers a settlement amount, that if they reject that amount, it automatically means that they're willing to negotiate. Well, sometimes that's true. However, there are instances where it's not, where the defense simply turns around and says, listen, this is the amount we are offering. We are not going to offer any additional money. You either take it or you don't take it. If you turn around and reject the defense's offer, what you're really saying is, look, you'll accept what's behind door number 2. Now, that's another way of saying, we'll take whatever the jury comes back with. We will wait for the jury to return a verdict to decide how much money they are going to give me as full and fair compensation for all the harms and losses and damages that you incurred because of your doctor's carelessness. So that is the possibility. More likely, you're going to have additional settlement discussions. That's more likely to occur, where now your attorney goes back and makes a counteroffer, the defense comes back and tells you either yes or no, that they will accept it, or they will make their own counteroffer. And now this is the process of negotiation. At some point, one side or the other is going to turn around and say, there will be no further discussions. We are only going to accept this amount. Or, on the other hand, the defense comes back and says, listen, we are not going to offer a dime more than this amount that we have finally offered. At that point, you and your lawyer have to have a detailed conversation about the risks of not accepting the offer versus the risks of going to trial and not knowing what the jury is ultimately going to do. Because there could be many different variations of what a jury could ultimately do. Because remember, you are now entrusting your case to 6 members of the community who know nothing about you. They have not lived with the case for years and years like you have, and now they are going to have to be educated about all the minute details of every single thing that happened during the course of this case, and why you believe you have a valid meritorious case, and that you are more likely right than wrong, and entitled to receive a verdict in your favor. So, are you willing to take what's behind door number 2? Or are you willing to accept a guaranteed amount of money in order to settle your case right now? The answer is not clear-cut. So why do I share this information with you? I share it with you to give you a sense of what really happens when the defense now starts to negotiate and they make a substantial settlement offer. It's critically important that you have a detailed conversation with your attorney about the risks of this settlement offer and what's behind door number 2. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if you are thinking about bringing a lawsuit, not one that's already in progress, I can't help you there, but if you're thinking about bringing a lawsuit and haven't done so yet in New York, and now have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.